activities that have been being investigated by the police. So maybe what the CS should advise is for the witnesses who are likely to be persons of interest to be interviewed in camera, so that we are not denied the benefit of their testimony.
Thank you.
So there are some levels of ability that maybe might go even to the minister's door.
Yes.
Which we are not sure.
Yes.
So if we are being that a certain witness cannot appear, that will be to some extent curtailing our investigation. And I think the CS as a lawyer should be aware of this, that those whom we feel, they feel that their evidence should be heard in camera, we shall hear it in camera, so that we protect the witness and also we protect the investigations that are going on. Thank you.
Thank you, Senator Faki. Maybe before the minister proceeds, any other comment? Senators online, senators in person?
I have something too.
Yes, Senator.
Yeah, I support Senator Faki completely, and I am not very sure whether the CS is able to answer all the questions we would want to ask the witnesses. So I suggest that we see these witnesses in camera, because I am sure the CS is as new to this issue as us who are investigating it. We are all in the same boat. But those witnesses are the ones who were there before, and they are able to give us the answers which the CS is not able to do. So I suggest we see those people in camera. Thank you, Chair.
Thank you, Senator Shakila. Any other senator who wants to make a comment? Senator Cheptumo, did you ask for the seat? Are you on record? Oh, I've not even put you on record. Can you put yourself on record? I thought I put you on record.
Yeah, that is what happens when you come late. Thank you, Chair. My name is William Cheptumo, Senator Baringo County, and a member of this committee. Karibu Wasire.
Thank you. So maybe, Minister, you've heard the comments from the two senators online. Maybe you might want to make a rejoinder, and then we proceed.
Honorable Chair, the case I have made is in the national interest. It's not to try to undermine this committee or any institutions of state. I am under oath, constitutional oath, to protect the country's security, and part of that security protection includes where offenses have been committed to ensure justice is realized. I have said, Chair, I've told this committee that some of the officers you want to talk are suspects. They don't even know. Others are witnesses. They will be witnesses. Some even don't know. And the information we have, they don't have. So the request I made is in good faith. It's not trying to obstruct you or demean the committee or look as if there is anything that the government of Kenya is hiding. I would have been happy to provide as much assistance as possible to this committee to realize its mandate on behalf of the security agencies, because from where I sit, those that you think will give you information will not give you that information for various reasons. Some don't have it. Others have it, but they won't give you because they are the ones who are the cause. And as you know, they are protected under the criminal law against self-incrimination. So they will not. They will come, you will see them, they will take you routes, they will waste your time. I would rather you even spend more time with the minister. You might make some progress. So I don't want to belabor this application because it's a preliminary matter. It's up to the committee to make its decision. The committee is an independent organ of the Constitution. You make your decision. I have already told you, you can drag a witness before you and get nothing out of that process. And all what we want as Kenyans is the truth and justice and accountability to every person, including managers, including security managers. And I've said before this committee many times, they'll also have their day. They will pay. All of them. All of them. If there is anything the Minister for Security who is addressing this committee should have done and didn't do and caused the kind of tragedy that is unfolding every day in Shakahola, I have no business even being in office. So I was just helping the committee. But if you insist, it's well and done. You can interview whoever you want to interview. My caution, and I say this with great respect, the committee may not achieve anything other than just forcing somebody to come and be photographed before you. Thank you.
Okay, this is the ruling of the chair. Having had both the minister and the senators concerned, we shall allow the minister to make presentations, and I direct that all the necessary questions be asked, and in the event that we see that the information is not available directly from the minister, we will then request the minister to make available that witness, and where that information needs to be in camera, the necessary application will be made. So, Minister, proceed.
Much obliged. Honorable Chair, we have been asked to provide information to this committee on a number of issues, and the first is on whether there was any formal complaint that had been registered with the various security offices in Kilifi, Malindi, concerning the matter under inquiry. I state as follows: that yes, there were reports made, and the prime suspect, Mr. Mackenzie, is not new to the criminal justice system. He has been doing the things that has caused this tragedy for years, since he arrived in Malindi sometime in 1995, where he was a taxi driver up to 2003, and from 2003 he started his church, which he called Good News International, and there's nothing international about that church, and there's nothing good. The only thing that has persisted is the news, and the news about him is bad news. Honorable Chair and members, when he started preaching, it took a little time for the residents of that area to realize this was a criminal. First, he was preaching in one of these members' homes, and then they fell out. Then he went in a nearby place called Furuzi, which is outside Malindi town, and started his church there in 2004 after 1 year. Then he preached for a while there, but throughout his preaching there was a lot of controversy, and around 2019 he closed that church. sold it, including the TV channels, to Mr. Ezekiel Ombok, another pastor in the same area. And that was in 2019, and he moved in 2020 to Shakahola Forest to do the things that he was doing there until we arrested him this year in April. There were formal complaints. There were formal complaints because, as a result, and I'm tying this with the question which came later, or rather the other issue which I was asked to clarify, which is the action after these reports were made, is because of the activities of Mr. Mackenzie that he was arrested. First, Mr. Mackenzie was arrested on 14th March 2017. He was arrested alongside one Winnie Alexander and another Betty Mwaka. The criminal case is number 182 of 2017. The three were jointly charged with the offense of offering basic education in an unregistered institution, contrary to Section 76 and 92 of the Basic Education Act. That was in 2017, Honorable Chair. Today is 2023. The first encounter with the criminal justice system against Mr. Mackenzie was 6 years ago. And I've given you the case number as a manifestation of the action taken by the authorities. He was teaching children and not licensed to do so. So that is a charge the prosecution preferred. Now, he entered into a plea bargain with the prosecution, which again, as you're aware, the prosecution is an independent institution. So some of the decisions they make, they cannot be questioned by the minister or by people because of our constitution. And I'll come back to that point, Chair. We must ask ourselves how far independence goes. Because of our trauma as a country in the past, we sought too much independence of certain organs over and above what is required for them to be functional. The result of it is institutions which are supposed to secure national security and national interest are undermining the same ideals. And they are flashing independence. They are saying we are independent, but I don't know how far. We have to decide going forward how far the independence of institutions should be taken. So the ODPP entered into a plea bargain, and Mr. Mackenzie, as a result of the plea bargain, was released by court, and he was told by the court, the trial court ordered him to be of good behavior, which is one of the outcomes of a plea bargain. He was told go home and behave well. He didn't. He was charged again. The same year he was arrested again. A report was made. For someone to be arrested, there must be a report. So he was again arrested the second time. Remember, the first one was 14th March 2017. The second arrest, Honorable Chair, took place the same year after he has been told to go and behave well. A few months later, in October, 6 months later, the date is 17th October 2017, he was charged with 4 counts. And among the 4 counts, one of them is a serious offense. And I'm not saying the others are not offenses, they are offenses, but one of them is a serious offense. Honorable Chair and the other lawyers in the House, you know about the hierarchy of crimes. There is a hierarchy of crimes. We have the most abominable crimes, both national and international laws, and they go escalating like that. Every crime is a crime, but we have a hierarchy of crimes. Among the 4 counts for which Mr. Mackenzie was charged with was the offense of radicalization under Section 12D of the Prevention of Terrorism Act number 30 of 2012. As members may know, offenses under the Terrorism Act are some of the most heinous offenses, and they are treated differently. She was charged, and I must praise whoever the officers who are responsible for taking action, for taking them to court, for prosecuting him and charging him. They charged him under the Terrorism Act. He was also charged on the same day with other offenses now, which I consider lesser offenses in terms of the threat they pose to national security. He was charged with offering basic education in an unregistered institution, contrary to Section 82 of the Basic Education Act of 2013. He was also charged with failing to take his own children, to compulsory primary and secondary education. As you're aware, primary and secondary education is compulsory under our laws, Section 30 of the Basic Education Act. And finally was charged with failing to provide the right to education to many children, contrary to Section 7 of the Children's Act, Cap 141 of the laws of Kenya. Those were the 4 counts in 2017, the second round of arrest. The first arrest was aborted because of a plea bargain, and then the court orders good behavior. There is no good behavior. He continues to do the same things. He's brought to court 6 months later, charged with a number of offenses under the Education Act, but principally with one major serious offense under the Prevention of Terrorism Act. Honorable Chair, the court took a number of measures. As required under the Children's Act, the court ordered that children protection files be opened, reports be made by the children welfare officer, and curiously, Chair, the court granted him bail on 19th of October. After 1 week, they set him free. They granted him a cash bail of 100,000 shillings. And Mr. Mackenzie was also asked, in the alternative, if he didn't have a cash bail of 100,000 shillings, to post a bond of 500,000 shillings. And other than that, he was not asked to behave well. He was asked to report to the OCS of Malindi, the officer commanding station, Malindi, once a week. The court also ordered that that matter be heard on a priority basis because, and here I commend the court said this was a public interest matter. Now, Chair and members, one can pause there and ask a few questions, and some of this information I'm giving is answering to some of the other issues because they are related. As I've said, I commend twice in 6 months attempt to bring this man to justice and to prevent him from causing harm to society. He's a religious man, he's a preacher, but we must commend our authorities, those that made sure this fellow is taken to court. Because there is some mote of fear we have built as a society, which is also damaging The same way I've said, as a country, there's too much reverence on institutions to allow certain institutions to be so revered that they can veer off from the national interest. Might hurt us in future. Maybe not in this generation, it will hurt us, because the state is formed by certain primordial and basic interests that make the state exist. Without the existence of those very basic conditions, all the things we speak here about, I don't know, the powers of the executive, the independence of the judiciary, the paramountcy and the supremacy of parliament, they remain paper matters. And that's why I argue these things are good for democracy, but there must be a state first for us to exercise constitutional powers, for the executive to project its executive powers, for parliament to exert its sovereignty as people's representatives, for the judiciary to exert its independence as arbiters and interpreters of the law. But if there is no state, where will be the judge? Where will be the members of parliament? Where will be even members of cabinet if there is no state? So my worry as a Kenyan and as the minister responsible for our national security, I am saying, in my view, I don't see the basis why, in the first instance, where a fellow who was indoctrinating children entered into a plea bargain simply because we can't ask the prosecution questions because they're independent, and then the judge sets them free to cause more danger and harm to the society. Right? But I must commend those who made sure there is a bit of accountability. 6 months later, the same fellow is brought before a judge. There's an improvement. The judge says this is a matter of public interest. It should be heard in priority basis. The judge also says that at least he must, he will not just be released like that. Let him pay a cash bail or post bond, but small amounts of money which he paid one may pause there also and ask, were not detained under the Prevention of Terrorism Act for which they had been charged, because that act allows the prosecution to hold and the police to hold a suspect for as long as possible, up to 1 year at a time, because of offenses under the Terrorism Act. So it is okay, the decision to charge him with terrorism related offenses like radicalization was good, but it had no effect. The courts released the fellow despite the fact that he's being charged under terrorism. And maybe we can excuse the judiciary, because from the record and from our investigations up to now, no application to detain him was made. And you can't blame the judges. If the prosecution did not make an application for the detention of this person under the act under which he was charged, then you cannot blame the judiciary. Honorable Chair, that was the second encounter we had as the state with Mr. Mackenzie. the preacher man from Shakahola. Shock of shocks. Even after the lapses which I've already pointed, and those are just two of more lapses, institutional lapses, criminal justice lapses. I have about 7 or so lapses which I've already identified, which if they had not occurred, we would not be where we are today. Shock of shocks. Even after those lapses, Mr. Mackenzie and company were released under Section 210 of the Criminal Procedure Code. For those who are not lawyers, Section 210 of the Criminal Procedure Code, the release under that section means that the accused is never put on their defense. In other words, the court, after listening to the prosecution, arrives at a decision that the accused has no case to answer and therefore should not be put on their defense. This same Mr. Mackenzie and you know, unlike a release under Section 87A, where the person can be rearrested and discharged, once a release is under Section 215, they are not put on defense, and therefore the matter ended at that stage, and Mackenzie found freedom to go back to Malindi to hurt more people and to damage our society. Honorable Chair, were reports done? Yes, they were done. Many reports. Mr. Mackenzie had a third encounter with the criminal justice system in 2019. Honorable Chair and members, on 13th April 2019, Mr. Mackenzie again was charged in Malindi criminal case number 366 of 2019 with 3 counts. 1, incitement to disobedience of the law, contrary to Section 96 of the Penal Code. He had incited the public to disobey the law and said many things and asked the public not to obey the law. Yet our Constitution says the rule of law is a cornerstone, foundational principle for the existence of the state. So yeah, he's an anarchist. He believed that people should not obey the law, and he's a preacher sent by God to make sure that people don't obey the law. And yet they're in Kenya and we have a constitution. He was also charged with being in possession and distributing films to the public which had not been examined and classified by the Kenya Film Classification Board, contrary to Section 12 of the Films and Stage Plays Act, Cap 222 of the laws of Kenya. Thirdly, he was charged with operating a filming studio and producing films without valid filming licenses from the Kenya Films Classification Board, contrary to Section 4 of the Films and Stage Plays Act, Cap 222 of the laws of Kenya. The court granted the accused person a cash bail of 500,000 shillings, and in the alternative, a bond of 1 million shillings with one surety for the same amount. If I was a judicial officer, this is someone who has appeared before me not once, not twice. This is the third time. The offenses appear quite serious offenses. If I was a prosecutor terms of the weight and the attention I should have given my case to sustain the prosecution would be different. As a judicial officer, I will do what judges do, and that is to take judicial notice of certain things. This person has been here, this kind of crimes, and the consequences to society are of this nature. I believe if those factors were considered, all these litany of matters would have been handled differently. We didn't do it because we are casual and we respect institutions, so people can do what they want until people die in their hundreds and everybody is very concerned and looked very remorseful and looks very concerned and is pointing fingers at everybody else except themselves. So, Honorable Chair, the appearance of Mr. Mackenzie before court at the moment is the fourth appearance. And it was triggered by two children who died on 20th March 2023 and were buried in shallow graves which were discovered thanks to citizens, Kenyans, and other members of society who helped us discover, because that is what triggered the current security measures that we are taking there. We are coming in very late. The damage cost is extensive. So these two children, Seth Inzano and Evra Ditongala, they were starved to death and buried in shallow graves within Mr. Mackenzie's farm. And Mr. Chair, again, I have heard some of the evidence that has been given before you suggesting that Mr. Mackenzie did not own the farm. That's neither here nor there. I can confirm to you the ownership of that farm is a complicated matter. But Mr. Mackenzie had informal lease between himself and some people purporting to be residents of that area. Whether those people had any claim to the ownership of that land is neither here nor there. And for purposes of the criminal justice system, it matters not to us. The fact remains Mr. Mackenzie had physical possession, had, whether in real or purported terms, acquired the entire 800 acres and was in possession of certain contractual arrangement between himself and people who purported to own that land. For purposes of criminal law, that's what matters to us. He was in charge of that territory. And he did very many things which he was doing there to show that he was in charge and he believed he was the owner of the land. So when these children died out of starvation, that's when reports started emerging, and we arrested Mr. Mackenzie on 23rd of March, 2023, and we sealed that place on 19th of April 2023 and started the current operation, which is ongoing. Up to now, we have recovered 238 bodies. Just for record, I remember yesterday I said 339. There are 338 bodies. But that was by yesterday. By evening yesterday, another 12 were recovered, so it's 350. And we have approximately 40 graves which are not opened that we have identified, and we suspect some of those graves are holding multiple bodies. I also confirm, Chair, that we have not exhausted our search for graves, and therefore we do not know how long it will take, because we cannot just rush. We are following the Geneva Protocol on the processing of mass graves and the protocols under international law on handling scenes of crime where atrocities have been committed. So it's a very slow process and very painful, and that's where we are. At the moment, we are sure of approximately 40 unopened graves, which we suspect some of them, the experts are telling them, from the look of things, they could be holding multiple bodies. And we have not exhausted the search for graves. I also want to bring to the attention of this committee chair, with regard to the activities inside the forest, from around 2019, when Mr. Mackenzie was chased, actually was chased by the residents of Malindi, including the local leaders, some of them. I know my sister, the Cabinet Secretary for Public Service and Gender, was the Member of Parliament of that area and had a bitter fallout as the MP with Mr. Mackenzie. So it's the residents who actually forced him to shut his shop. It is not the law enforcement agencies. Because as I have shown, we were arresting him, taking him, he is released, we arrest him, and so forth and so on. The residents were fed up with him and they chased him. He disappeared to the forest. When he entered that forest at the end of 2019, early 2020, and let me put it this way, Chair, you have been to Shakahola. It is on the edge of the human